Good morning. You're Jared Dobson.
No.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Get this pulled up. Sorry, it's taking a minute.
Okay.
See, Mr. Dobson, cause number 25, DCCR 1492, you're charged with the state jail felony offense of theft of material, copper, from June 30th of 2025. Your indictment alleges you were previously convicted of the state jail felony offense of theft, March 28th of 2019, and after that was final, you were convicted of burglary of a building and state jail felony, August 11th of 2020. And how do you plead to that charge? And are those two prior convictions true? And did you enter your plea of guilty and true freely and voluntarily, and because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in a deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Dobbs is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of theft of material, find those prior offenses true, sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification. That shows that this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you.
All right, sir. Your Jetson Bell.
Yes, ma'am.
This is cause numbers 25 DCCR 0108, 0109, and 0110. And Mr. Bell was set for trial over in drug court. There was a couple of issues with a video and also with obviously the jury. Have y'all been able to watch that video today?
All of them, yeah.
All right. And is there any change with regard to any plea negotiations or anything like that?
Not from our side, is that correct, Mr. Dunn?
Yes.
So you want me to put your case back on the trial docket? We'll get it tried as quickly as possible. Is that what you want, Mr. Bell?
Yes, ma'am.
And I do want to go back. It looks like the last plea bargain rejection was in October. And it was so we've gone over this before. If you get found guilty and your prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years, up to 99 years or life. You recall that and you understand. And it looks like the offer then was for the minimum of 25. Is that still the offer?
Actually, we had come down from that, Judge, I think maybe before trial
Yeah.
last time. And I think it was 15 years TDC or a cap of 20.
Okay. Well, at this point, you've seen everything. You still want to go forward with trial. There will not be any plea agreements accepted after today. Do you understand? And the only right way there would is if some new information came to light that your attorney or the district attorney did not have in their possession at this point. You understand? As far as you know, Mr. Smith, does Mr. West have all of the discovery at this point?
Except for the video copy that was made, I must have copied the wrong disc, but I will have this copied and it will be available this afternoon.
Okay.
upstairs.
And we've looked at all of it.
And you've been,
But they have
so,
looked
Yeah,
at
we've
my
looked at
copy
his
of
copy,
everything.
yes.
okay, sounds good. Then we'll get your case set on the next available trial docket. All right, you can go back with the bailiff.